Well, good afternoon, ladies and gentlemen. It's really lovely to see so many of you here at this, the last CELS lunchtime seminar for this academic year. And it gives me great pleasure to introduce you to Professor Carlos Moreiro, who's an old friend of mine and colleague and a good friend of the university. And he's very kindly come here to talk about one of the most pressing issues facing the European Union at the moment, which is, of course, the rule of law and the issues around the rule of law, particularly in respect of Poland and Hungary. And he has a lovely title, The Rule of Law as a Fundamental Value of the European Union, a Supranational Concept in Progress. Ladies and gentlemen, I introduce you to Carlos. He will talk for about half an hour. There'll be time for questions. For those of you who are watching online, and I can see there are a number of you, please would you put your questions in the Q&A box and I will pick them up from there. And anyone in the room, I'll take the questions orally and just repeat them so that those online can hear them. Carlos, the floor is yours.
Well, thank you very much, Catherine. Thank you very much, Albertina. It's really very nice thing to have you here, and thank you to all the people that work in the Center of European Legal Studies of the University of Cambridge. Thank you also to your colleagues at the Trinity College, because they have been extremely kind during these days there. Obviously, I'm not here to talk about the Northern Ireland Protocol. I think that for the last seminar, you were waiting for something like that. But probably, although the United Kingdom is not anymore a member of the European Union, the question, the issue that we are going through in my lecture, it's of some interest, even not only for the students of the University of Cambridge Faculty of Law, but I consider that for the whole of the population in the United Kingdom, because at the end of the day, what we are going to deal with in this lecture is the health of democracy. And democracy, as you know, it's not something that you can guarantee that will be preserved forever. We have to take care of democracy almost every day. As Professor Barnard told when she introduced me, my contribution is divided into parts. The first one is about the elaboration of the notion of the rule of law in the legal system of the European Union, which, as she said, is a concept in progress. And then I will move forward, going through an analysis of how the rule of law is now regarding in the secondary legislation of the European Union. I have to say that it's quite a technical subject, but I would try to be as clear as possible. And I hope that you don't get bored too soon. So thank you very much. I'm going through. The rule of law constitutes one of the supreme or fundamental values of the Union. As established in Article 2 of the Treaty of the European Union, its respect is compulsory and a compulsory common obligation for all European institutions and the member states. This means a legal obligation that the latter must respect, in order to join the Union, Article 49 of the Treaty of the European Union, but also to keep on belonging to this international organization, as it is a common union acquis. However, the treaties do not define the concepts, nor identify the elements comprising the rule of law, despite the fact that all the articles of the Treaty of the European Union implicitly, as is the case of Article 7, or explicitly, as is the case of Article 21, paragraph 1, refer thereto. This absence of a regulatory definition is also found in other provisions of the treaty as for key legal concepts, such as public order, public safety, and national security, as you can see in Article 4, paragraph 2 of the treaty, Article 52 of the Treaty of the Functioning of the European Union, and Article 73 of this same treaty. and in relation to the essential security interest of a member state, like you can see in paragraph 1 of Article 346 on the Treaty on the Functioning of the European Union. Since these are concepts stemming out of the contemporary constitutional traditions of the nation states, the development of a supranational concept for each of them is a comprehensive and unfinished process, as it is dependent upon the conflict on competences between the institutions of the Union and its member states. In fact, up to date, no exhaustive definition of this concept has already been provided by means of any secondary legislation of the European Union, leaving the case law of the European Court of Justice as the preferred means. It's being limited to establishing exclusions from national jurisdiction on a case-by-case basis, but we cannot provide a supranational definition for each of them. As regards the concept of the rule of law in Article 2 of the Treaty of the European Union, it bewilders us more than the treaties do not expressly identify all or some of its components, for two reasons. On the one hand, because unlike other disputed concepts, the rule of law is not established as a restriction on the exercise of supranational rights or freedoms, but rather as a guarantee for their exercise. On the other hand, because its inclusion in Article 2, the Treaty of the European Union from the Maastricht Treaty, constitutes an axiological evolution as compared to previous provisions of the treaties, such as Article 2 of the Treaty of the Economic Community, European Economic Community. This provision read for full employment, price stability, a sound external balance, and economic growth as mere economic guidelines for achieving the objective of political integration. These Leitgedanken, as German says, guidelines, guided the action of the institutions and member states, but were not fundamental values or even justiciable values. According to some scholars, this conceptual gap was filled in by the case law of the European Court of Justice in the initial years of the integration process, long before even the execution of the Maastricht Treaty, establishing the principles of primacy and direct effect as laid out in the Costa versus Enel and Wangen-Loos judgments, as these created ex novo subjective rights and established obligations for their protection by the public authorities of the member states. Indeed, the law of the then European communities was unquestionably a self-contained set of rules, principles, and institutions capable of sorting out the problems set out in the economic integration plan with a constitutional logic of its own, in which the aforementioned principles of primacy and direct effect had only a functional value. In that legislative context, it was almost dreamlike to assimilate the terms community law and rule of law. The weakness of the connection between these two concepts that some scholars have inferred in light of the Costa and Wangen-Loos judgment and subsequently on the Los Verdes judgment expresses only a legal trend, but not the existence of a legal system fully comparable to the rule of law. This, amongst other reasons, as community law at that point in the process of European integration did not have a specific duty to safeguard human rights. The rebellion of the constitutional courts against the application of the principle of primacy demonstrated the existence of a legal dispute that could not be overcome by legal logic. It could be said that the relativization of the principle of primacy during that period of the integration process questioned the very legitimacy of the community legal order due to its pre-democratic or a-democratic character. So we can state that in such legal context, all supranational decisions were based on what Luhmann defines as mere legitimation by procedure. It was precisely this democratic deficit, the feature where the German Constitutional Court placed its main emphasis when it reluctantly accepted the adaptation of the Maastricht Treaty to the German constitutional system, drawing up intangible limits on the principle of attribute powers. This line of argument no longer called into question the role of the European Union law in view of its commitment to the protection of fundamental rights, but already warned that any extension of the Union's powers could only take form by an express attribution from its member states. The strengthening of the democratic principle as a source of legitimacy for the Union's decision, as stated in the Treaty of Lisbon, has not prevented a resurgence in the resistance of some constitutional courts against the implementation of the principle of primacy. Such is the case in Romania, Poland, and France. All these decisions have in common a rejection of the expansion of the Union's powers through Praetorian activism, especially with regards to special sensitive areas for national sovereignty. In such circumstances, it seems inappropriate to rake on the court the serious responsibility of setting the parameters for respecting the rule of law. However, some progress has been made in recent years thanks to the action of the European Parliament and the Commission, which I will address now. According to Article 2, Paragraph A of Regulation 2020-2092 of the European Union, the rule of law includes the principles of legality, meaning a transparent, democratic, pluralistic, and accountable law-making process, legal certainty, prohibition of arbitrariness of the executive powers, effective judicial protection, including access to an independent judicial power that protects fundamental rights, separation of powers, and non-discrimination and equality before the law. This provision is based on existing supranational regulatory precedent and other soft law decisions of European international organizations that attempted to identify the essential elements of the concept at hand. As this is a rule of secondary law, directly binding on all addressees, the definition acquires a dimension of justiciability that Article 2 of the Treaty of European Union lacks. This is confirmed by the judgment of the European Court of Justice in cases C-156/21, Hungary versus Parliament and Council, and C-157/21, Poland versus Parliament and Council. Thereby, it was rejected the applicant's argument alleging violation of the principle of legal certainty because the regulation does not define the concept of a rule of law or the principle which is based on. The court states that those principles have been widely developed in its case law, arising out of the common values recognized and applied equally by the member states within their legal system, and which stems out from a concept of rule of law, which the member states share together and to which they adhere as a common value to their constitutional traditions. Consequently, member states can only on an individual and precise basis determine the requirements for the implementation of each principle. However, it should be noted that Article 2 of Regulation 2020-2092 establishes a definition of the rule of law in a sanctioning legal instrument, which creates a regime of conditionality for the protection of the European Union budget. Thus, some question relating to its justiciability must be addressed. First, under what circumstances could those violations of the rule of law be prosecuted? Second, is this regulation complementary to the sanctioning procedure provided for in Article 7 of the Treaty of the European Union? And third, could the member states invoke the sovereign rights reservations preserved by the treaties, such as Article 4, Paragraph 2 of the Treaty of the European Union, in order to hinder its implementation? Going to the first question, under what circumstances could those violations of the rule of law be prosecuted? Pursuant to Article 3 of the regulation, endangering judicial independence, allowing arbitrary decisions by public authorities, or limiting the effectiveness of justice by various means may be considered breaches of the principles of the rule of law. Since this is not an exhaustive list of scenarios, and these are also stated generically, many others could be considered, although as provided for in Article 4, Paragraph 2 of the regulation, only those breaches that affect or may seriously affect the union budget in a sufficiently direct way will be prosecuted. This specification is highly relevant because it increases the burden of proof for the claimant. Regarding the second question, is Regulation 2020-2092 complementary to the sanctioning procedure under Article 7 of the Treaty of the European Union? Article 7 of the Treaty of the European Union provides for a preventive procedure in the event of a clear risk of a serious violation and of a sanction procedure in the existence of a serious and persistent violation by a member state of the values of Article 2 of the Treaty of the European Union. Although the rule of law is not expressly mentioned, there is no doubt that both mechanisms established by these provisions are directly or indirectly intended to protect the rule of law. However, to date, both mechanisms have been applied only on a very exceptional basis and have had no relevant legal consequence so far for the warned member states. Thus, for example, with regards to the application of the preventive mechanisms, Article 7, Paragraph 1 of the Treaty of the European Union, reference can only be made to the European Commission's proposal relating to the interference of the Polish government in the independent functioning of the judiciary, and to the European Parliament's proposal relating to the various threats to the rule of law in Hungary. For example, lack of independence of the judiciary, corruption, administrative opacity, violation of rights of political participation and fundamental rights, and fraud in various electoral processes. As is well known, neither proposal succeeded due to the Council institutional neglect, a circumstance which has resulted in actions only being pursued to date by way of Article 258 of the Treaty on the Functioning of the European Union, despite the fact that the European Commission itself had previously warned that this was not the most appropriate means for prosecuting breaches of the rule of law in the Union. The various judgments of the European Court of Justice in proceeding under Article 258 of the Treaty on the Functioning of the European Union have been based primarily on the second paragraph of Article 19.1 of the Treaty of the European Union, such that, strictly speaking, there has not been any judicial review of Articles 2 and 7 of the Treaty of the European Union, despite the fact most of the complaints for breach also expressly allege violations of both provisions. Nor has such judicial review taken place in the context of other procedures, such as those provided for in Article 267 of the Treaty on the Functioning of the European Union and 269 of the same treaty, although the court's decisions in those cases are less quantitatively relevant. On the other hand, since nearly all the cases decided by the European Court of Justice are based on the second paragraph of Article 19.1 of the Treaty of the European Union, the court focuses almost exclusively on questions relating to the functioning of the judicial system of the member states concerned, in particular on judicial independence, but does not address other elements pertaining to the concept of the rule of law. Let's go through the third and last question. May member states invoke the sovereign rights preserved by Article 4, paragraph 2 of the Treaty of the European Union to prevent the application of Regulation 2020-2092? Article 4, paragraph 2 of the Treaty of the European Union, establishing the principle of respect for the national identity of the member states, was also introduced into the constitutional foundations of the European Union by the Maastricht Treaty and developed more concisely by the Treaty of Lisbon, a regulatory paradox when we compare to Article 2 of the Treaty of the European Union. Specifically, this provision distinguishes between the respect for fundamental political and constitutional structures and the essential state functions, identifying two complementary levels that refer, in the first case, to the organization of democratic life, and in the second case, to the very survival of the state. This difference is relevant for the purposes of weighting the extent on which the European Union may hinder the implementation of the principle of respect for the national identity of a member state. In fact, the treaties establish several provisions empowering member states to disregard European Union law in situations that threaten their essential safety interest or their own survival, like, for example, Articles 42.7, 78.3, 222, and 347 on the Treaty on the Functioning of the European Union. A circumstance which is not provided for in relation to respect for their political constitutional structures, with the exception of the emergency brake mechanism of Articles 82.3, 86.1, and 87.3 of the Treaty on the Functioning of the European Union, or even as stated in Article 6 and 7 of the Protocol on the application of the principles of subsidiarity and proportionality. Since the treaties promote a process of political, legal, and economic integration, it is clear that Article 4.2 does not establish a reservation of sovereignty, nor that is guarantee the non-interference of the European Union in the internal affairs of the member states. This is confirmed by many judgments of the European Court of Justice. Nevertheless, when it comes to specifying the extent of the Union interference in order to ensure rule of law standards in the functioning of a member state's powers, in particular its legislative and judicial powers, the member states concerned do not accept this by peaceful means. just as the mysterious silhouette of Nessie resurfaces, likewise, thus the question of the limits of the implementation of the principle of primacy as a legal tool of the European Court of Justice. In short, as a means of interference by the Union, we challenge the Court when it exercises its duties as a guarantor of the application of European Union law, as well as at the level of the member states. In fact, some scholars qualify the exercise of supranational judicial powers as a tool to impose the tyranny of values. However, a detailed analysis of the decisions of the European Court of Justice on this issue reveal the institutional caution with which it acts. Thus, for example, the European Court of Justice repeatedly justified its jurisdiction by differentiating between the competence of the member states to determine the organization of their internal powers, namely the administration of justice, and its own jurisdiction, which is limited to ensuring that member states exercise their powers in compliance with the obligation arising under Union law. This legitimate interference in the field of the powers of the states might occur independently of the ground that gave rise to the breach of obligations, whether it is an abuse of power that affects judicial independence, or that affects the right to a judge as established by law, or the formulas for selecting judges and the composition of the courts of justice. The caution with which the European Court of Justice acts in justifying its judicial review should be highlighted, since it only assesses on a case-by-case basis the adequacy of the conduct of the member states with respect to Union law. But it has not taken advantage of this context to replace the legislative power by trying to establish a minimum threshold for respect of the rule of law, with the sole exception, perhaps, of establishing a principle of no regression, according to which member states cannot lower their standards after having become a member of the European Union. In short, we are facing with a troublesome scenario in which efforts to support the rule of law on the basis of the legitimacy of the Union are developed based on a weak regulatory framework, the lack of a definition of the concept in primary law, the contextual nature of the only instrument of secondary law that offers a non-exhaustive definition, Regulation 2020-2092, and the European Court of Justice self-restraint that protects on a case-by-case basis some essential elements of the rule of law without seeking to establish a supranational conceptual standard to date, even when it has already declared them to be general principles of European Union law. It is true that during this parliamentary term, the concerted action of the European Parliament and the Commission has made it possible to implement new mechanisms for the protection of the rule of law, such as the development of standards linking it to the procedure for monitoring the economic and budgetary environment of the member states in the so-called European semester, which was supported by the European Parliament and which is being applied rigorously and relatively effectively. Similarly, a framework was developed by the European Commission in March 2014 to address systemic threats to the rule of law in any member state, which allows the Commission to initiate a dialogue with the state concerned to prevent systemic threats from escalating. This framework was conceived as an alternative to the procedure under Article 258 of the Treaty on the Functioning of the European Union. None of these has succeeded in establishing an agreed constitutional culture surrounding the rule of law in all member states of the Union, capable of guaranteeing their unanimous adherence to the values of Article 2 of the Treaty of the European Union. Let's go with my final remarks. The protection of the rule of law within the European Union is influenced by various circumstances that prevent uniform standards from being guaranteed at the level of all member states. First, although the rule of law is a fundamental value of the Union, according to Article 2 of the Treaty of the European Union, the lack of a comprehensive definition in secondary law deprives it of direct justiciability. Second, the mechanism established by the treaties, mainly Article 7 of the Treaty of the European Union, and more recently by secondary law, Regulation 2020-2092, in order to guarantee the rule of law, essentially have a sanctioning function, which today has been ineffective. It still remains to be seen whether it will ultimately be effective, despite the recent actions by the European Commission against Hungary and Poland. Third, the absence of an agreed supranational paradigm on the concept of the rule of law has as a consequence an understandable dispute of powers between the institutions of the European Union and its member state when it comes to identify the scope of application of such sanctioning mechanism. There is a discretionary power of each member state on the organization of its constitutional powers within the framework of the democratic rule of law that is not strictly defined. This dispute of powers allows some member states to engage in unique interpretations of the exercise of their sovereign powers on the basis of Article 4.2 of the Treaty of the European Union, and to take advantage of various circumstances to hinder the supervisory powers of the European institutions. The current international crisis of the war in Ukraine is a clear example. Fourth, the European Court of Justice cannot become a rule maker that fills in the aforementioned regulatory gaps. In addition to damaging its institutional independence by having to advocate a regulatory paradigm that is not based on a consensus among the member states, the European Court of Justice will slow down or even prevent a supranational definition from being developed through such consensus. However, a change in the circumstances in the short or medium term could be expected if, as is foreseeable, following the conclusion of the work of the Conference on the Future of Europe, the convening of a new convention will make possible a definition of the rule of law to be included in the Treaty of the European Union. Thank you very much to all of you.